rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is State v. Perry, and we will hear from the appellant.
May it please the court, Mr. Chief Justice, Associate Justices. My name is Jeff Jackson. I'm here with my co-counsel, Stacey Phipps, on behalf of the North Carolina Department of Justice. It is our honor to represent the state. I request 5 minutes for rebuttal. This is a sufficiency of the evidence case. This court is very familiar with those cases and with the standard. As applied to this case, the legal test is as follows: whether, viewing the evidence in the light most favorable to the state, a rational juror could have found the taking element of robbery with a dangerous weapon. This is going to turn on a close reading of the facts, as most sufficiency cases do. So here is a quick recap of the facts. The victim goes to the apartment of his friend, Miss Lynch. It is, according to him, roughly 8 p.m. It is dark. He arrives there, walks in the front door, sees what he says are 4 people sitting behind the door. He walks through the apartment, out the back door, speaks with someone once outside, then circles back around, re-enters through the front door. This is when an unidentified woman strikes the victim in the head with a pistol. The victim falls to the ground but remains conscious. Then a man, later identified as the defendant, strikes the victim in the head again with a pistol, at which point the defendant and several other men begin stomping on the head of the victim. The victim has a broken jaw in more than one place, 2 busted teeth that later have to be surgically removed. He says what happened next was they threw me out in the road. This was the road that ran adjacent to the apartment. When asked what is the last thing you remember, he says being thrown out in the road. When asked what happened next, what do you remember happening next? He said a car was coming. I put up my hand to stop it. Good Samaritan then gives him a ride back to his apartment. His roommate is his niece, and he tells his niece everything that happened, and sometime later, his niece says, you need to go to the hospital, and they take the victim to the hospital. Those are the essential facts.
What facts in the record let us know how long he was unconscious in the road? Because what I saw was he testified it was an indeterminate length of time.
You are absolutely right. There is no clock time in the record. There is no estimate from the victim as to how long he was unconscious in the road. There is, however, we submit circumstantial evidence that would allow us to get a rough sense. So I'm not going to say we know how long he was in the road, but it is not accurate to say we have no idea. Here's some of the circumstantial evidence that the jury would have been able to consider. First, it was a trafficked roadway at approximately sometime after 8 p.m. But we're no reason to conclude, no reason to rationally infer that we're talking 2 a.m., 3 a.m., anything like that. Second, the victim was in a lot of pain. Teeth broken, jaw broken. A rational inference that this pain was having the effect that it tends to have, which is to get someone's attention. Third piece of circumstantial evidence, indicating that his unconscious period was for a matter of moments or minutes, being his after-the-fact behavior, in that he was able to get himself up, apparently speak with the Good Samaritan enough to say, I need you to take me home, and here's where I live. And then upon getting home, was able to converse with his niece and tell her everything that happened. More consistent with a temporary blackout than with a prolonged period of being unconscious. There's also the fact that, according to his testimony, he was the one who stopped the car. He was conscious for that. He didn't need someone to shake him and wake him up. So, those being the essential facts, we submit there are two ways a rational juror could find the state met its burden here. The first is roadside discovery, and the second is hospital discovery. The difference between these two is when the victim discovered his possessions were missing, because there are, in evidence for the jury to consider, two theories. One, that he discovered his items were missing before he got into the Good Samaritan's car, so he stands up and does one of these and realizes his keys, his phone, and his $250 are missing. And then another theory in which he discovered his items were missing when he was at the hospital. I'm going to start with roadside discovery. I'm going to start there for two reasons. First, I think the appellate court made a mistake here. I think that mistake is clear, and I think it is determinative. If I can prove to this court's satisfaction that the court did make this mistake, I think it makes very quick work of this matter. So here's the error. The first footnote in the appellate ruling speaks to roadside discovery and the manner in which the jury heard this evidence. The manner in which the jury heard this evidence was not on direct testimony, direct examination by the victim. It came in initially for another purpose. It was the statement the victim gave to the detective when he was at the hospital. And in that statement, the victim says, essentially, I discovered my things were missing when I was on the road. And in the first footnote for the appellate ruling, the court says, yes, that was the statement the jury heard, but this did not come in for the truth of the matter. And this is incorrect. I submit this is plainly incorrect and determinative of the outcome of this matter. Here's why. It is true that initially it came in for another purpose. But on cross-examination, defense counsel made the decision to let it in. The reason defense counsel did that is because they were marching the victim through, on cross-examination, his statement to the detective, likely for the purpose of setting up an impeachment in close to try and show daylight between the victim's direct examination and what the victim told the detective at the time. So defense counsel was saying, okay, and then you told the detective this, and then this, and then this. And in that process, reads to the jury the victim's statement to the detective about roadside discovery. And we know that this came in for the truth of the matter because the trial judge caught it. And in the motion to dismiss colloquy, one of the attorneys, in talking about this portion of testimony, says, well, Your Honor, that doesn't come in for the truth of the matter. And the judge says, yes, it does. This is on page 496 of the transcript. I submit this is the most important part of the entire record, is page 496. I'm going to read you exactly what the trial court said. The setup here is the attorney has just said, well, Your Honor, that doesn't come in for the truth of the matter. And the judge says, quote, well, it is for the truth of the matter. Because on cross-examination that came in. It was not for the purpose of impeachment. It was new information. So while this document itself is not in evidence, what the alleged victim said is in evidence. And that statement would support it going to the jury. Because the point the victim noticed the things missing was when he was laying in the roadway, which means not only did the trial judge explicitly rule that the jury was allowed to consider this for the truth of the matter, the trial judge himself understood the testimony from the victim to indicate roadway discovery. And what's particularly odd about the appellate ruling is they seem to agree. If you look at page 2, it states the victim, quote, woke up in or near the road, injured, and missing some of his possessions. Right next to the footnote where they basically say the jury couldn't consider this, the appellate court's own recounting of the facts indicates roadway discovery. The bottom line for what this means for your consideration of the question, why we believe this makes quick work of this case, is because it collapses the timeline. We're no longer talking about time at a hospital. We're not talking about time in an apartment. We're not talking about time in the car of the Good Samaritan. Now, under roadway discovery, the assault and the discovery of missing items are almost flush against each other. The only gap in between them, to Justice Riggs' point, is the period of time in which the victim was unconscious. We submit that that is sufficient under this court's precedent to allow the jury to rationally infer a continuous chain of events. If you look at State versus Baker, a similar set of facts in which there was a half-hour period of elapsed time. We're going to talk about a handful of elapsed time cases. 30 minutes was the amount of elapsed time in Baker. We don't know precisely what the amount of elapsed time was here, but there is, as I recounted to Justice Riggs, circumstantial evidence to believe that the jury could have inferred a blackout of moments to minutes.
Let me ask you this. Should we take into account that apparently the victim was, he thought, visiting a friend, and then the perpetrators did what they did to him? Can the jury consider, okay, these people that perpetrated this did it out of just pure meanness, or they had a motive to do something else?
Your Honor, that's an excellent point, and it is a perfect segue to the next item here, which is the 404B evidence that the jury heard. The 404B evidence, by the way, incredibly specific, relevant to these facts. What did the jury hear? That the defendant, on a previous occasion, had pistol whipped someone and robbed him. Precisely the facts here that the state alleged occurred. The limiting instruction that the trial judge gave the jury was that they could consider that 404B evidence for the purpose of intent and common scheme and plan. So there are a number of hypotheticals in which the defendant wasn't the person who robbed him. There are a number of speculative hypotheticals that we could engage in. The appellate court refers to this as interloping thieves possibility. And we could engage in a lot of that. But at the end of the day, every one of those hypotheticals, if you're in the shoes of the jury, is being compared to what they know to be the case. Well, this person pistol whipped him with the intent to rob him. They know that because of 404B. They're allowed to infer that. That alone, however, is insufficient for the state to prevail under sufficiency. I'm not going to stand here and say, and we did it in the brief, that 404B evidence alone is sufficient. This court's been clear that intent plus opportunity is not enough, but intent plus opportunity has been proven such that what is required in addition to that is slight and circumstantial. And in the case of roadside discovery, what the circumstantial evidence is that allows the state to easily meet its burden is the narrowness of the gap being reduced solely to the period of time in which he was unconscious. If we are to imagine that interloping thieves actually were the cause for roadside discovery, then we necessarily must imagine the following. A pedestrian happens upon this man, bleeding, severely injured, apparently deeply unconscious, decides to rob him, does so by going through his pockets in a manner that doesn't alert him, and then makes off with his stuff. All plausible, but in the shoes of the jury, let's call that theory A. Theory B.
Don't you also, under that scenario, don't you also have to assume that the people who assaulted him did so not to rob him, but just out of meanness?
Well, Your Honor, I think the acting in concert instruction covers whether the defendant participated, to what extent they participated,
Well, I'm talking about the motive for the assault. I mean, can't the jury logically say, I wonder why these people did what they did to this
Yes.
victim?
Yes, absolutely. They could question that. And if the jury had decided at the close of all the evidence that they simply weren't persuaded, perhaps that would have been their outcome. However, in light of the 404B evidence, we know that they had a rational basis for inferring the intent, because this is exactly what this defendant did on a previous occasion. When asked to confront, as the rational juror in this matter, the interloping thief of the pedestrian who happens upon this injured person and decides to rob him, versus, well, what if it was the person who pistol whipped him with the intent to rob him? I think it's very difficult for this court to call the jury wholly irrational by saying, well, actually, it was the person who pistol whipped him with the intent to rob him. And that is the test here.
When I look at the precedent, though, that looks at the time that's elapsed, it's sort of in conjunction with a little bit more clarity that there was an interloping thief, right? So the woman is assaulted at her workplace, her purse and her wallet were there, then they're not. This is more of a, what if it fell out of his pocket somewhere? Like, you don't have to show that the defendant has the stolen property, but it isn't, it seems to me it's just, is there a case that helps me get over what I see as a distinguishable element, that because there's this no clarity about time and it's a roadway and it's dark, if it fell out of his pocket, you know, I just think in the other cases we've seen, the combination of time and the lack of clarity of whether there was an actual taking as opposed to a loss, like those two have an interplay that worries me.
You're right. Those cases do have an interplay. It's along the lines you just described. I think of it as elapsed time on the x-axis and exclusivity of control on the y-axis. So you described the Skinner case, in which case the woman who was badly beaten in her own home had her things, had the money on her counter, such that this court was able to determine, even though 3 hours elapsed, well, she had exclusive access because it was in her private residence, versus the case of Moore, in which money was on the counter, but the counter was in a store that was open to the public. So this court said, even though the elapsed time was 40 minutes, much less than Skinner, we think that's insufficient because no exclusivity of access. Clearly, this court finds exclusivity of access to be a key factor, and it relates to elapsed time. The exclusivity of access is a huge point in favor of the state, because this wasn't just on his counter at home. It was on his person. It was in his pockets. Access does not get more exclusive than that. Now, this is going to function differently for hospital discovery than it does for roadside discovery. And we're about to get to hospital discovery theory, but just for roadside discovery, you're certainly correct that while the Court of Appeals talked about interloping thieves, they also could have speculated misplacement as a theory. I think misplacement gets extremely tenuous under roadside discovery when you have circumstantially inferred moments to minutes of being rendered unconscious, and he's in one location. He was conscious, according to his testimony, when they dragged him to the road, and then he woke up in the road. Was it rational for the jury to assume, well, actually, the most likely cause of his missing items is the person who pistol whipped him with the intent to rob him, versus, well, maybe while he was in the road, his money, his phone, and his keys all fell out of his pockets? Misplacement in the road, certainly possible, but you wouldn't say that a jury was being wholly irrational by deciding, actually, we think it was the man who pistol whipped him with the intent to rob him. But this does bring us to hospital discovery.
Before you go to hospital, I just have one question about Davenport, because it seems to me that in that case, very similar, it was a cell phone and money that was missing. And the different element in looking at all the evidence that the jury was permitted to consider and all the inferences that we should take in the light most favorable to the state, in Davenport, you also had the jailhouse confession. So you had very similar facts in terms of he had the money before the crime, he had the money in the cell phone, did not have the money in the cell phone after the crime. But here, so is your contention here? It's the 404B evidence that provides that additional, that gives us something more than just he had the money before the crime, did not have the money after the crime.
In short, yes.
Okay.
The fact that the jury is starting at third base with this person pistol with him with the intent to rob him would be the something extra commensurate to what we saw in Davenport. Okay. With respect to hospital discovery, the reason we have to consider this is because there was some evidence in the form of testimony regarding hospital discovery from the victim. It came in the form of a leading question, but the jury certainly was allowed to hear it. And in the event that we're considering hospital discovery, now we are back in the land of a number of hours of elapsed time. And now we're talking about exclusivity of access. The difference between Moore, in which the money was on a counter, but that counter was in a store that was open to the public, so 40 minutes was deemed insufficient, versus Skinner, in which the money was on the counter in a private home, so 3 hours was deemed sufficient. We, as I recounted to Justice Riggs, assert that exclusivity of access here is a point for the state because it was on his person. However, opposing counsel is still going to say, you're still dealing with a big block of time. How do you answer that? Here's how we answer that. In these cases, this court has pretty clearly recognized special privilege for the jury's consideration for Good Samaritans. And we allege, if you look at the evidence, that the victim was in the custody of a continuous chain of Good Samaritans, picked up by a Good Samaritan in the road, back to the apartment with his niece, who, expressing concern for him, takes him to the hospital, at which point he is under the care of nurses and doctors. From the jury's standpoint, if they're asked to entertain an interloping thieves theory, who among these Good Samaritans were they wholly irrational in saying, well, actually, it was probably them and not the person who pistol whipped the victim with the intent to rob him? Skinner. Classic Good Samaritan situation. A woman, 70-year-old, badly beaten in her own home by an assailant who then leaves. Now remember, Skinner is the money on the counter in her kitchen. While she's there, bleeding badly, friendly neighbor, Good Samaritan, comes in, finds her, calls the police. It's the police that find the missing money from the wallet on the kitchen counter 3 hours later. In a sufficiency review, this court didn't say that the jury was wholly irrational by refusing to consider the possibility that the Good Samaritan was actually the person who robbed this woman. And by the same token, this court has never said, well, actually, the jury was wholly irrational by failing to consider that the police officer wasn't the real culprit. So, in the shoes of the jury, what would have been more likely? That the doctor whose care this victim was under decided to rob him, or that it was the person who pistol whipped him with the intent to rob him? It's very difficult to point at one of these Good Samaritans and say the jury was behaving wholly irrational by not speculating that actually that's the real culprit here. And the victim was in the custody of a continuous chain of Good Samaritans. Last point I'll make, this is a bit of a global point. There is a public policy impact to your ruling here today. This court would understandably, rightfully, be very reluctant to rule in a manner that creates an incentive for violence. And if this court holds that the mere fact of being rendered unconscious means that the state cannot prove sufficiency, means that robbers now know in North Carolina, well, I better render my victim unconscious before I rob them. And that simply cannot be the law in our state. Unless there are any further questions, I'll reserve the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court. My name is Kaylin Sweet, and I represent the appellee in this case, Damarlo Perry. Mr. Perry will be asking this court to affirm the unanimous end result, unpublished Court of Appeals opinion, which reversed his conviction for robbery with a dangerous weapon. In that opinion, the Court of Appeals held that the state failed to present substantial evidence that Mr. Perry, or anyone acting in concert with him, took Mr. Scott's cell phone, house key, and $250 cash in conjunction with his assault. Where the state failed to present substantial evidence, the Court of Appeals properly found that the trial court should have granted his motion to dismiss that charge. In other words, this case should never have gone to the jury in the first place. Importantly, Mr. Perry doesn't challenge his conviction for the assault. And because he was sentenced concurrently for both of those charges, he will serve the remainder of his active sentence, regardless of this court's decision in this case. This is still an important one, however, because as both sides would agree, for the state to secure a criminal conviction, they bear the burden of proving each element of each alleged offense. And the state must be held to that standard of proof. Where it falls short, it must also be held fully accountable. This case isn't about a failure of the standard itself, rather the state's failure to meet that standard based upon the evidence presented during Mr. Perry's trial. Accordingly, this court's analysis, as I think we both agree, should be narrow and incredibly fact-specific to Mr. Perry's case. This court should affirm that the state failed to present substantial evidence that he committed robbery with a dangerous weapon for two specific reasons. First, as my co-counsel mentioned, the state failed to present critical timeline evidence to prove the assault and alleged taking of Mr. Scott's property were so closely related in time as to form a continuous chain of events. And second, the state failed to present evidence that Mr. Perry acted on any alleged intent to rob Mr. Scott, whereas co-counsel mentioned that intent was based solely upon 404B evidence that he participated in a robbery 10 years prior to his trial in this case. In reaching the decision to reverse Mr. Perry's conviction, the Court of Appeals properly considered the state's evidence as a whole, properly considered the overall evidence in a light most favorable to the state, and properly either analogized or distinguished the evidence presented in a series of precedential cases which provide guidance on this issue. Accordingly, the Court of Appeals committed no error of law by reversing Mr. Perry's conviction for robbery with a dangerous weapon, and this court should so affirm. Jumping directly into substantial evidence, because this is such a critical point in this case, substantial evidence, I agree with my co-counsel, is such relevant evidence that a reasonable mind might accept as adequate to support a conclusion. In other words, the state's evidence as presented during trial can guide the jury to reach a logical conclusion based upon, and this is the important part, established facts. The state's evidence, he's correct, may be either direct or circumstantial and still meet that threshold to be considered substantial. The state's evidence may not, however, merely raise suspicion as to an essential fact at issue, in this case, the taking. The state's evidence may also not require the jury to guess, to imagine, or to assume any essential fact at issue. And finally, the state's evidence may not require the jury to reach a conclusion about an essential fact at issue based upon incomplete information presented during the trial. Yet that's
why can't I understand that you can't use 404B evidence alone to satisfy all the elements of an offense, but why couldn't you, so in this case there's substantial evidence that your client struck the victim, pistol whipped the victim with the butt of the gun. So if then the jury hears evidence that in an earlier event, your client did that exact same thing but then robbed the victim, why can't the jury use that as common plan or scheme evidence to say, I understand these actions that the defendant engaged in, and because there's such similarity between that event and this one, we can now infer that the rest of that plan or scheme was carried out by this defendant and not someone else?
I would answer that question by saying this goes to Chief Justice Newby's point, that there still has to be evidence presented by the state to show that he acted in this time in accordance with that intent. So just because he had intent 10 years prior under a different set of facts, he may have had the intent in this case. But because we're human
Well,
beings.
that's why I was using the common planner scheme and not intent.
Justice Dietz, I believe that this was just admitted under the limited purpose for intent, according to the jury instruction that was given by the court at the time. So if the state had wanted the court to consider common planner scheme, that should have also been included in the jury instruction at that point. So I would argue that intent is the only thing that evidence was proffered for. And where the state failed to prove that he then acted on that intent, they have failed to present substantial evidence that a taking took place. Turning to the first point, the state failed to present evidence that the assault was so closely related in time to the discovery of Mr. Scott's property that these two acts could be said, as the case law requires, to form a continuous chain of events. And this goes to Justice Riggs's point. We have critical gaps in this evidence. The only time period presented in this entire case, and I believe the state concedes this point, is that Mr. Scott arrived at the apartment where he was assaulted at 8 p.m. on May 18th of 2021. Beyond that, despite his testimony, we have no evidence of how long he was there prior to the assault. We have no evidence of how long the assault itself took. No evidence of when he was thrown outside into the roadway, which, as the state mentioned, was the last thing he remembered prior to becoming unconscious. And no evidence, as to Justice Riggs's point, how long was he unconscious in that roadway prior to discovering the property?
Of course, one reason why we don't have this evidence is because the victim was knocked unconscious. How do you respond to the state's point that the Court of Appeals opinion incentivizes wrongdoers to knock their victims unconscious?
Justice, I respond to that in two ways. First, the state had opportunity to present evidence which would have narrowed that timeline, even with the victim being unconscious. And that is through evidence of when he arrived home after the assault. This court has heard that there were two witnesses present during that time that were not ill or infirm in any way and could have potentially testified that he arrived home at midnight or at 2 a.m. or at 4 a.m. But they weren't even interviewed by law enforcement, and they certainly weren't called as witnesses for the state. There also could have been evidence of when Mr. Scott arrived at the hospital after the assault. And even though he didn't know how much time had elapsed between leaving the apartment and arriving at the hospital, and that's on page 314 of his testimony, the state called two separate medical witnesses to the stand, yet failed to ask the essential question, what time was he admitted? Either of them, using the referenced 3,700 pages of Mr. Scott's medical records, could have simply looked, and that would have at least helped to narrow the state's timeline in this case. The final thing that they could have done was called law enforcement and asked them, when did you respond to the hospital? Detective Kramer in his testimony mentioned that two responding officers came from the Kannapolis Police Department. What time did they get there? That would have certainly been noted in their report, yet the only evidence that the court had to consider was that he arrived at 8 p.m. on May 18th and went to the hospital sometime on May 19th. Well, was it at 12:01 a.m. on May 19th? That would have given us roughly a 4-hour time frame, could have potentially met some of the standards set by the case law. Or was it at 8 a.m. that day, in which case we have a 12-hour swing in that time frame? Either of those things would have helped to narrow, and that's how I would answer your question in that regard. The state brings up several important cases, and in my opinion, that goes to highlight the critical nature of this timeline evidence. Williams indicates a continuous chain of events could be found based on 22 minutes of time frame. Baker, like the state mentioned, 30 minutes, still a continuous chain of events. When we start getting outside of that time frame, 2 hours in the Moore case, not a continuous chain of events. And 7 hours in the Holland case, certainly not a continuous chain of events. Where the state failed to present anything to assist this court in narrowing that timeline. They simply failed to present substantial evidence. There's nothing for this court to plug into existing precedent that would allow you to make a determination. Is it more like the Baker case? Is it more like the Moore case? Without the timeline evidence, there's no way to make that determination. And this matters because where the missing property is discovered close in time to an additional offense, it lessens this opportunity for, as the Court of Appeals called, interloping thieves or unexplained loss to take place. It narrows the gap that other circumstances could have occurred outside of it being directly connected to the assault. Moving to the second point, and the state didn't spend much time on this, but the Court of Appeals found it incredibly important that the state failed to show Mr. Perry acted on any alleged intent that he may have had based on his previous robbery. And there is ample case law to explain how the state could have shown that he acted. And it really would have required very little on their part during trial to present this evidence. Was there evidence that Mr. Perry told someone about his plan to rob Mr. Scott? We're talking about an apartment full of people in this case. The victim himself testifies, I believe, to at least 9 other people present, aside from himself. In the Call case, we have evidence that in the weeks prior, defendant had discussed robbing the victim with a friend in an effort to recruit his help. That friend was then called as a witness during trial. So the jury was able to hear that a plan had been formed and was in place prior to the act being carried out. In this case, law enforcement admits we didn't interview anyone who was there that night. They spoke to the victim's brother. They spoke to an unrelated individual, Miss Farr, but they didn't interview anyone who was present. They also didn't search Mr. Perry's phone. And that's getting into an entirely different issue, but if we're talking about an alleged conspiracy between this group of people, certainly they would have talked about it at some point, and would that evidence have been there? Possibly. Was there evidence that Mr. Scott heard Mr. Perry or anyone else mention a robbery during the assault itself? This is from the Evans case, where the defendants were heard to say, "This is a holdup. No one's going to get hurt." Other examples would be, "Give me all your money." And in the first robbery, which established the 404B evidence, that is what the defendant said. The victim testified, or the victim presented evidence to law enforcement that he walked up to the person and said, "Give me your wallet." And that is what kicked off the entire event. That's not present in this case, at least not based on the evidence that the state presented. This is important because Mr. Scott, as the state mentioned, was conscious throughout the entire assault. He gave a lot of testimony about who hit him with what object, in what order, who stomped him, who kicked him, where he was in relation to the ground when he was standing. He knew all of that, yet fails to mention that anyone said anything about a robbery. That same point goes to the fact that Mr. Scott never testified anyone removed his property while he was in this apartment. If he was conscious enough to be aware of who was perpetrating what assault on him, he certainly would have felt someone reach into his pockets, if that's where the property was located, and remove it from his person at that time. And this is from the Williams case, where the victim testified the defendant grabbed her belongings and fled. In fact, when asked if he knew why the defendant would have pistol whipped him, Mr. Scott actually responded that he did not. And that's on page 318 of the transcript. The victim himself, at the time he testified, didn't even assume that it was because Mr. Perry intended to rob him. And this goes to Chief Justice Newby's point. The defendant gave an explanation as to what happened, and that is in the record below. Now, in a light most favorable to the state, I'm not going to stand and argue that before the court, but assaults happen because people are just mean. And this, in fact, was a case where the defendant assaulted the victim for a reason other than to rob him. And robbery itself is not a natural consequence of assault, not that this court has so found based on the precedent. Other evidence they could have presented Mr. Perry was in a poor financial position at the time. We don't have any evidence of that. In the Dover case, the defendant regularly borrowed money from the victim and others, including a waitress. The defendant owed money for court costs and probation supervision fees. He was 3 months behind on his power bill. There was evidence of this in the record that would, again, at least get the state closer to showing that he acted on any alleged intent. Same thing with the Palmer case. The defendant needed money to help him avoid prison for embezzlement and was angry with the victim for not helping him. There's no evidence presented in this case that Mr. Perry was in any such financial position. He owned a vehicle. We know that because the state searched it when they found him still in the exact location 2 days later. There was no evidence that Mr. Perry was caught with Mr. Scott's property after or any suspicious property. And the state makes the point in their brief that these are small, transient items. People may spend cash immediately. They may sell a phone. They may toss a house key. But the ultimate fact is that Mr. Scott's property was never recovered. In the Dover case, even though the defendant denied taking the victim's money, he was found on a jail phone call telling her exactly where he had hidden it in a trash can. Lo and behold, it's nearly the exact same amount that was taken from the victim's residence. Similarly, the defendant was known to never have money, and yet the officers who arrested him observed him hand his girlfriend a wad of cash from his wallet as he was being arrested. In Mr. Perry's case, the apartment at 600 Atlantic Court was searched. His vehicle was searched. His person was searched incident to arrest, and nothing was recovered. And that includes the firearm that he allegedly used to pistol whip Mr. Scott. Finally, there was no evidence that Mr. Perry fled the scene or attempted to conceal anything from law enforcement. And this goes to Justice Earle's point about the Davenport case. In that case, the defendant got rid of this very distinct white and red sort of tracksuit that he had been wearing earlier in the evening. And then he also told law enforcement that he was home all night, despite the cab driver testifying that he had taken him twice to the residence of the victim. In this case, Mr. Perry was in the exact same apartment 2 days later when law enforcement came to speak with him. He consented to an interview with the lead detective, waived Miranda, and against his own interest admitted, yes, I assaulted Mr. Scott. He gave a reason, and again, I'm not asking the court to consider that reason in a light most favorable to the state, but the fact remains he denied this robbery. The state's evidence cannot be merely speculative, and that's where this case fails. In their brief, the state argues that someone must have taken this property. And I would encourage the court to realize that that is the assumption that the state is asking you to find. But an assumption, by its very nature, is not based on established facts. Because if you have to assume it, you don't know it. And if you don't know it, it hasn't been proven. And that's exactly what the state's asking you to do in this case. First, with regard to the timeline. They want to say that the timeline is collapsed and that the two events were flush against each other. Well, based upon what? They're the authors of the trial in this case. They get to control how the evidence is presented. And I submit to the court with just a few additional questions asked of the existing witnesses or a few additional witnesses that they knew how to locate, they knew where to find, and they could have called, they might have met this threshold. Again, this is not a case where we're asking the court to change the standard that's existed since 1945 when this court decided Murphy. And to the Attorney General's point that this will create violent criminals, and I believe Justice Allen's question to me, this standard is not new. If there are violent criminals that are reading this court's opinions and determining how to commit crimes on that basis, they've been doing that since 1945. State versus Murphy is identical to this scenario. Even in that case, though, the court said there was a 10-minute time frame that the defendant was unconscious, and they still didn't find that that was enough evidence or substantial evidence for the state to prove that a taking had occurred from an unconscious person. A couple of points based on the roadside discovery. The state contends that the timeline should be collapsed because this was a trafficked roadway. Based on what? Law enforcement wasn't asked, is this a trafficked roadway? Is this a trafficked roadway at 8 p.m.? Is it a trafficked roadway at midnight? What about at 4 a.m.? We don't know because there was no question asked and therefore no evidence presented in the record. The state indicates that this can be reasonably inferred to have happened at 2 or 3 a.m. Based on what? It is their job to present the facts in this case so that the jury can make a decision. The state also says that this is consistent with a temporary blackout. Based on what? This is the consistent problem with attempting to have the jury assume what you are trying to put into evidence. Medical experts didn't say anything about it being a temporary blackout. They weren't asked about his period of unconsciousness at all, even though logically they would have been the perfect people to testify that these specific injuries at this level would have left him unconscious for 5 minutes, 30 minutes, 4 hours. We don't know because there's no evidence in the record below. Because again, the state failed to present it. I'll tell you, I wasn't even going to argue the hospital discovery because I think in a light most favorable to the state, roadside discovery is probably the most narrow that this timeline gets, and I'll give them that point. But hospital discovery is even worse. When you're talking about Good Samaritans, the court still has to evaluate their credibility in the courtroom. We don't know anything about these people. The state's, again, assuming that they're Good Samaritans, but the jury was given no opportunity to evaluate their credibility at trial. The trial court was given no opportunity to evaluate their credibility at trial. And this goes against the very function of the jury as they're instructed, which is to say all of the facts have been presented here at trial. You must decide based on those facts alone what you find the evidence to be. Based on those facts alone, how could the jury have possibly assessed the credibility of two people who were never presented to them for that assessment? This court has long recognized that evidence which merely shows it is possible for the fact at issue, in this case the taking, to be as alleged, or which raises a mere conjecture that it is so, is an insufficient foundation for a verdict and should not be left to the jury. And that is the crux of this case. And that is why the Court of Appeals reversed this conviction, because it recognized the jury should never have been asked to decide this. They weren't given complete information. They were essentially handed a logic game that didn't have enough clues in order to be solvable. Accordingly, where the state fails to present substantial evidence, in this case that Mr. Perry committed this robbery, this taking of Mr. Scott's property, the Court of Appeals properly found that the trial court should have granted his motion to dismiss that charge and as a result properly reversed his conviction. Mr. Perry respectfully requests that this court affirm the Court of Appeals' opinion. And if there are no additional questions from the justices, I would cede my time. Thank you.
Thank you, counsel. Rebuttal.
May it please the court, I'm going to make 3 points. The first is going to be about the amount of elapsed time while the victim was unconscious. The second is going to be about alternate theories of intention, the meanness possibility. And the last is going to be reiterating something about hospital discovery. So I think opposing counsel makes an excellent point with respect to what we're asking, what the state's asking this court to do with respect to roadside discovery, given that we have an indeterminate amount of time. We don't have a number of minutes. So opposing counsel says, we're asking you to plug this in to an existing precedential matrix in which all of those cases, Moore, Baker, Skinner, they have with them a certain number of minutes, certainly an estimate in all of those cases, but you've got a number. And we don't have that here. And that's true. So the reason why we're still comfortable asking this court to consider doing that is a few reasons. First, we do think there is circumstantial evidence that a rational jury could have considered to infer an amount of time, that being the fact that he was on a trafficked road, not in the dead of night, sometime around 9 p.m., that he was in extreme pain from the face, tending to wake one up and get one's attention, his after-the-fact behavior being cognizant, more consistent with a temporary blackout rather than someone who was injured so severely cognitively they were out for a number of hours, as is speculated. Then we get into the public policy. It simply is, to Justice Allen's question, a public policy implication here if this court says because we don't have a number of minutes, because this person was rendered unconscious by their attacker, therefore it is insufficient by definition.
General Jackson, I assume you want prosecutors in this state to carry their burden in criminal cases. It seems to me there's a public policy interest, too, that I worry people take the wrong message from if we don't say, do some work to establish a timeline. I'll grant you investigating, interviewing other witnesses, calling other witnesses, maybe starts getting into second guessing prosecutors and law enforcement. But if you'd even had one question about what time he got to the hospital and you had the medical witness there, it's a totally different story. I mean, I think what you just called circumstantial evidence requires a medical testimony that I didn't see in the trial about head injuries and what happens at some indeterminate time in the road. Do you see what I'm saying? I think there's another policy interest at play, and I wonder how you deal with that.
There is another policy interest at play. It is exactly the one that you stated. And to opposing counsel's point, could there have been other pieces of evidence entered that bracketed this matter at various points along the way? Absolutely. But this court has established precedent for these sufficiency cases in a really clear way. It has made the bar as low as the bar gets in the land of appellate review. Did the jury behave in a rational way? I submit you do not need to have a medical license in being a jury, hearing this evidence that he was in intense pain, that it was a trafficked road, that he was conscious when he stopped the vehicle, that after the fact he was able to have a cognizable conversation, and for that to form a rational basis for an opinion about how long this person was unconscious. I disagree that it requires a medical diploma in order to form some type of reasonable basis for bracketing how long this person was out. It's another piece of circumstantial evidence that points to the elapsed time of how long this person was unconscious, at least as to the alternate theory of how this person could have been robbed. It's not as if anything else could have happened to this person to explain away why he's missing his items. He had to have been robbed in the street by a pedestrian, happening by him, seeing him injured. All of this is basically, this is theory B that the jury is being asked to consider. It is simply not irrational for the jury to say, actually, we think it is more likely rational that the person who struck him with the intent to rob him was the real reason why he's missing his things. As to alternate theories of intention, I think 404B cures all of that. Is it possible that this person did not strike him with the intention to rob him? Absolutely. Is it irrational for a jury to infer intent where they've been instructed by the trial judge they're allowed to infer intent based on 404B? It's completely rational for a jury to behave in that manner. Let's say this court decides I'm wrong about roadside discovery, that the lack of a determinate number of minutes is just prohibitive in reaching sufficiency. That gets us back to hospital discovery, in which case we do have a continuous chain of Good Samaritans. And if this court reviews all of the sufficiency cases, you will see Good Samaritans in and out of all of these. Some professional, some not professional. There is, I would submit, an implied doctrine already existing in this court's case law recognizing special privilege of Good Samaritans when we're considering what a jury could have rationally based certain conclusions on. For those reasons, we ask that you find in favor of the state. Thank you.
Thank you, counsel.